Item number 1. Item number 2.
Please, Lordship. Lordship, here I am challenging the impugn order dated the impugn order dated 027/2025, Your Lordship, passed by the London Secret Bench in WPC number 75 of 2025. Here, my Lord, let me narrate a brief fact of the case, my Lord. That impugn order is that page 98. The related it's starting from 97 till 100.
Suspension was pension.
Yes, my lord.
Lordship.
Suspension.
Suspension.
Yes.
So who are you? You are the
Lordship. Yes, Lordship. What happened? I am the wife of the private respondent. Now, private respondent hearing.
who is for the private respondent?
My
You are
lord.
the
I'm representing the private respondent. my lord.
your wife.
She's
Yes,
the wife. my
I'm
lord.
the wife. She's
So wife
I'm the
wants
pensioner, my lord.
your service is pensionable.
Yes.
So
I'm the wife, legal wife.
so
She has filed the maintenance case, my lord.
so once the maintenance case is pending, how there's going to be a REIT?
Yes.
In the
Lordship.
REIT petition, we cannot direct payment of pensionary benefits to you.
Lordship.
You may approach the council or the court for the purpose of your maintenance.
Maintenance.
If he is not maintaining you, REIT court cannot direct that.
Yeah, Lordship. That's why I'm not the person who filed the writ petition.
Yes.
The writ petition was filed by the private respondent, who is
I
my
filed the
wife.
writ petition, my lord, because the pension was not released to the petition.
Lordship,
So
let
how
me
you
just,
are agreed with
yes,
this?
let me,
Lordship.
let me narrate, your Lordship, what happened is. Yes, I let my
And in
friend,
fact, one of the
my friend,
No,
let
we
me
just
stop this.
No.
Yes,
We
Yes, now-
just thought our
yes.
clarification.
Yes,
He
yes,
made the
Lord.
submission. We got confused.
Yes,
with it.
Lordship. Now I am the wife of the private respondent.
Correct.
I have been with my husband for 15 years. Out of our wedlock, 6 children were born to us. Then when my husband, the private respondent, deserted me, I have filed the maintenance case. The maintenance case, there was some order to pay me around 6,000. And thereafter, after around 7-8 years, I filed another application for enhancement.
Enhancement. Correct.
After filing the enhancement, that enhancement was
Allowed.
not allowed, it was dismissed.
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 Okay.
And then in the enhancement, my contention before the subjudicial magistrate in the district council court was that enhancement also plus reach some service benefit to share some kind of 50-50 share of service benefit of my husband. That was dismissed. And thereafter, I filed an appeal before the appellate forum in the judge of the district council court. Now the revision, that case is still pending till today. When I filed, I have filed against the order of the dismissal of the subjudicial officer. I filed, there is appellate forum. When I filed, there is a stay by the judge of the district council have stayed the order of the subordinate court
The appellate forum.
in the appellate forum. Now, that order was stay, that dismissal order was stay, and then the revision petition that my appeal is still pending till today, till date, and next date is on 3rd November, which is coming, and they are also paying. Now, in the meantime, my husband, while the appeal case was pending before the appellate court there in the district council court, they have come suppressing the fact. They have come to the High Court and filing a writ, seeking direction from this court, for payment of the gratuity and other service benefit.
Pension benefits. Correct. Yeah.
Now, their case is for releasing the benefit and other service benefit, pension and other service benefit. I have filed an affidavit in opposition. Since the matter, where is that? This one?
You are
Since the matter was pending before the trial court, I said, since the same parallel proceeding is still going on, since they have never challenged the proceeding, what is pending before the...
You are Mr. Sangma.
Yes, Mr. Sangma.
Mr. Sangma, paragraph 5 of the impugned order
Yes.
is absolutely correct. Try to understand this. You have a maintenance proceeding pending. That will follow its own course. Correct? In the writ petition, the relief was that the state government possibly or his employer is not releasing the pensionary benefits. So that is wholly unconnected with in the what you prayed for, or rather what you urged in your affidavit in opposition. In fact, you are not a necessary party in that proceeding at all. You are not a necessary party in that proceeding at all because he asked for pensionary benefits. Now, if he gets pensionary benefit, that may be a ground for your enhancement or whatever is there.
Yes.
So that has no connection, no nexus with the prayer he made before the learned single judge. So paragraph 5 is absolutely correct.
Lordship, that's why let me clarify. In my petition was before the trial court was the enhancement plus sharing of the service benefit. That is a subject matter.
So that forum will decide. This order has not affected your right so far as the proceedings before the appellate court is concerned. Here, the only issue required to be decided whether he is entitled to the pensionary benefits or not. Appellate forum will decide on your maintenance and other service benefits if you are entitled to under the law. But that has nothing to do with this matter. Sorry.
Otherwise, my lord, the section 10 and 11 is attractive in this case. May I just that CPC where it is 10 section 10 and 11? May I just have on 2 minutes just read it.
Section 10 is a CPC.
Yes, CPC.
Stay of suit proceedings.
Yes, proceeding because.
So what could be a stay? There is nothing to be stayed.
Because I mean the same subject matter as I have mentioned, Lordship. Yes, Lordship.
No, you want stay of what? You want stay of what?
No, I mean when the same subject matter for there also for service matter for service benefit. As
no, what you want stay? You want to understand.
No,
so he doesn't get the pensionary benefits. That will not inure to your benefit. If he gets, that inures to your benefit. Take down.
Lordship.
The wife of the of the writ petitioner is the appellant. Yes. Yes, madam.
May please, Your Lordship, I'm appealing for the
I
appellant.
can't hear you, madam.
I'm appealing on behalf of the appellant, Your Lordship.
Yes,
in this
yes.
matter.
Last time you did not appear. No one was represented for the appellants. So, what is the subject matter of appeal? Please tell us.
Your Lordship, actually, this matter is conducted by counsels from outside, Your Lordship. Your Lordship, if this matter can come up on 3rd of November, Your Lordship.
3rd November.
3rd November, Your Lordship.
What is the subject matter? Please tell us.
Your Lordship, this appeal is based on the this a matter was filed, Your Lordship, in the single bench judge, Your Lordship, and based on the order dated 29/2024 passed in WPC number 386 of 2023, Your Lordship, this appeal has been filed, Your Lordship.
No, I just want to know that what is the subject matter. Yes, admittedly, his prima facie it appears that there is a violation of natural justice.
Yes,
You cannot have a blacklisting. You know that judgment in Eurasian equipment, that is the main judgment.
yes, Your Lordship.
Eurasian equipment is the mother judgment.
Yes, Your Lordship.
Are you aware of Eurasian Corporation?
Yes, Your Lordship.
So Eurasian Corporation, yes, it's also quoted here. If I may.
Yes, Your Lordship.
So if you cannot blacklist him without hearing him, giving an opportunity of hearing, that is a limited issue, madam.
My lord, if I may be allowed, my lord, I am appearing for the FCI respondent, my lord.
Yes, you are appealing for the.
FCI respondent, main respondent, my lord. That blacklisting was interfered with, and we have now they have come up only against the. We have not challenged the blacklisting, the interference of the
Now,
blacklisting
are you appearing for the appellant?
on behalf of the FCI respondent, my lord. I'm just wanting certain clarification, my lord. The appellant has now challenging the risk and cost factor, my lord.
No, the judgment says that there is a violation of the principle of natural justice. So, accordingly, in view of the observations given above, the part of the impugned order debarring the petitioner contained in para 7 is set aside and will be subject to orders that
Yes,
will
my lord,
be brought to the-
we have accepted that order, my lord. FCI
and you
respondent
have
have
given effect to
accepted
that.
that order.
You have heard them.
Now they have, my lord, they have come up with the another plea that the risk and cost factor which
Risk and
has
cost
been
liability.
imposed upon the petitioner contractor, my lord.
Which factor I can't follow?
Risk and cost liability, Your Lordship.
Oh, risk, yes.
Yes.
See, risk and cost liability will arise provided you don't fulfill the contract.
Your Lordship.
This liability, risk purchase clause, for example, the risk purchase clause and all the things, that clause has to be there in the agreement. You cannot question that.
Your Lordship,
You cannot question that, madam. But they have complied with this order. So if that is not the subject matter of challenging the writ petition, if you have not, have you challenged it in the writ petition,
Your
madam?
Lordship, actually this matters were conducted by the council from outside, Your Lordship.
No, I
I'm
just want to know from you.
Yes, Your Lordship.
See, loss and damage will be recovered is a risk purchase clause in the agreement tender. Now they have accepted. So question is this, that debarment goes. Am I correct, Mr. Counsel? So debarment goes.
Yes, my lord, department goes.
So it is a status quo ante. If it's a status quo ante, now you cannot challenge that particular clause. It's barred by constructive res judicata. You had the chance of challenging it. You have not challenged it before the first court. So in the appeal court, you cannot take a fresh point of challenging the contract. You waived your right to challenge it at the first place.
Your Lordship, if this matter can come
My
up on
lord,
3rd
if your
November,
lordship will,
it'll
if
be
your
more-
lordship will kindly may peruse the order, the paragraph 5 of the order, my lord, at page 248.
No, we have read it. That is what I'm saying. We read it. That's why we say Union Corporation was considered. No, debarment for 2 years has been waived now. So debarment of the 2 years, if it is waived, then the question of penalty would not come. if the department, this penalty, they have challenged the penalty as well in the writ petition.
They have challenged the penalty as well, but they have not raised that point before the learned single judge, my lord, which can be seen from the observation made by the learned single judge at para 5 at page 248, my lord. Para 5 of the judgment. May I read it, your lordship?
So you have
Para 5.
imposed the penalty as well as blacklisting.
No,
You impose the
blacklisting,
penalty.
since it has.
No.
Now we will.
Blacklisting is a consequence of the penalty. But two things
But there
follows.
was a two-part of.
Yes. For non-fulfillment, you can impose penalty and blacklisting. Both is possible. Penalty and
Yes, my
blacklisting. Now, if
Yes.
the
As per
blacklisting
the contract.
no, if the blacklisting goes, then penalty has a nexus with the blacklisting. Penalty cannot stand alone. Then you ask them to perform the contract, and whether
They themselves have stated that they will not willing to perform the contract, my lord. They have resigned from. We have given the acceptance letter. They have resigned from their the contract, my lord. Therefore, we have given a the notice.
no, it's a fresh cause of action.
No, it is not a fresh cause of action, my lord. By
No,
the same
that-
by the same
no.
order, we have imposed the resistant cost and also debarred him from for 2 years.
No, you see that debarment will be a consequence of penalty. If it's possible for you to impose only penalty, not debar him.
My lord, I will try to satisfy your lordship on third as stated by.
We are just hypothetically, let us discuss it. See, if there is a breach of contract, the two consequences follows.
I've taken note of your lordship queries, my
Just
lord.
give us 1 minute.
Yes,
For a
yes,
breach
my
of a
lord.
contract, two consequences follows. One is you accept the breach and sue him for damages. And another is you don't accept the breach, you require him to perform the contract. These are two consequences of a breach of contract. Now here what you have done is this, you terminated the contract by imposing a penalty and blacklisting.
Yes, my lord.
Now, if you are waiving the blacklisting, then penalty has also to be looked into, because the consequence
No,
of
we have-
blacklisting is as a consequence of the penalty. Because there's a breach, penalty, and blacklisting.
In fact, we have not waived the blacklisting, my lord. It was interfered by the learned single judge, and as
So
learned single judge has left.
if you accept this order,
My lord, subsequent to that order, we have issued the SOPA's notice why they should not be blacklisted, and thereafter we have blacklisted him, and that has not been challenged, my lord.
no, that is why I'm saying that after this order, if this order has been acted upon, and then you have given him a fresh notice and a fresh
Notice, my lord.
fresh notice. So this has to be only after your
Giving natural justice.
29th February 2024. 29th February
Yes, my lord.
2024.
After 29 February 2024, my lord.
And they participate in the said proceeding. They gave reply to the show cause.
Yes, they have replied to the SOPA, and thereafter, after considering their SOPA,
Madam,
if
if you have accepted this order, then your appeal has become influence. You may have a fresh cause of action. See, if there is a breach, they have given you a show cause. You have replied to the show cause. Now it is now a different proceeding altogether. If you are aggrieved by that thing, this order has lost its force because this order has been acted upon.
Your Lordship, because I'm not the main counsel,
Very well,
Lordship.
straight
If I think they'll be in a better
An
position.
adjournment
to
is
argue
paid for
this
on
out.
behalf of the appellant. The learned counsel Yes. Yes. Yes, this what happened. You are Mr. Hajarika?
Yes, my dear. Yes.
For the respondents,
For the state respondents, I'm appearing, Your Lordships.
you are Miss Yangi?
Mrs.
Yes. And
And for
you
the
are-
private respondent.
now you have changed sides. But last time you did not appear, it seems. Your name is not recorded in the order. You are representing respond numbers?
Private respondent number 4.
I'm for 1, 2, and 3, Your
5 and
Lordship.
6.
You are for?
1, 2, and 3.
Actually, you can record Korun. You have not recorded who is appearing for whom. And you are for 4 to 6.
Yes, my lord. 4 to 6.
Achha. So Miss Madak has appeared
Yes,
on that. Yes, very well.
my colleague.
Your call. Yes. Oh, your name is in the previous order. Yes. Yes.
May I please, Your Lordship? We are challenging the impugned order of learned single judge passed on 28 June 2000.
Please tell us briefly what the facts are.
No, I am telling, my lord. Brief fact of the case is that, my lord, as per the Mahatma Gandhi National Rural Employment Scheme, my lord, which was act in the 2005 and Meghalaya implemented in 2006, my lord, giving employment to the BPL family in the rural area 100 days. So the block development office has given the village, formed the village employment council, my lord, for a time of 3 years, my lord. So this video has approved our VSC, the Village Employment Council, on 6 May 2024, my lord.
Yes.
Then we have continued in the process, my lord. In the meanwhile, what happened, my lord? The private respondents party, and another is Blanchon Momin.
Is?
Another is Blanchon Momin, my lord.
Okay.
They have damaged we are making the dam in the hilly area for keeping the fish for the villagers, my lord. So we have filed an FIR on 11 September 2024. And they have also filed a counter FIR by the private respondent on the same date, alleging inter alia that we have misused the MGNRC fund, my lord. Then that one mutually, it has been withdrawn on 23rd September 2024, my lord. Thereafter, what happened, my lord? On 24th September,
Yes.
some people have come to our residence and forcibly obtain our signature in a type copy. We are being a woman, some man has come. And the next day, we do not know what exactly written in the type copy, my lord. Next day, we came to know that it is the resignation letter from us. So we have lost a complaint to the police. Then and there, what happened, my lord? There's private respondents, one Namson Momin and Blanchon Momin. They have written our resignation letter, original resignation letter with us. Then we have continued. In the meanwhile, my lord, somebody might have photostat this our resignation letter and submit to the block development officer, Damdamas CID block in West Garo Hills, my lord. On the basis of this, we do not know before, my lord. Then they have constituted another village employment council,
What is VS?
village employment council, my lord, for doing the developmental work in the villages, my lord.
Now, so according to you, the persons or the miscreants
Yes.
who have taken your signature on a blank paper,
Yes.
They have
No,
written-
but type copy, my lord.
on a type copy,
Yes.
they have written you the resignation letter.
Yes, later on.
Now, this resignation letter was submitted to whom?
No, this resignation letter they have to obtain from us.
So this
In the meanwhile, my lord, in the meanwhile, we have filed a police complaint, so they have returned it.
No, you have filed police complaint against the persons who have returned this letter to you.
Yes, private.
Against you are the private respondent.
Lordship,
So you have returned the original to them.
may I submit?
No, just
No,
for our understanding. Don't know that.
Yes.
That is for our understanding. So he returned the original letter to you.
Yes.
Now, this when you tender the resignation letter.
No,
the-
I am coming to that point, my lord. Then we have continued. So, and we have continued. Then on 6 December 2024, so BDO has approved the Village Employment Council, in short VSC, in favor of the private respondent number 4, 5, and 6, my lord. Then we have astonished how it has been happened. So we have filed a writ petition, and in the writ petition alleged that without notice, without giving an opportunity, how our VSC was, another VSC was constituted without dissolving us. So while the trial is going on in the learned single judge, my lord, this state respondent has filed affidavit, my lord. So I came to page number 55, my lord, in my writ appeal.
The petitioner herself, along with the secretary, had appended the signature to a resignation letter of 24/9/2024. So they acted on the basis of this resignation letter,
Yes,
which, according to you,
yes,
was returned to you by the private respondents
Yes.
after the FIR was lodged.
yes. Here in the 7, they are alleging that we have submitted our resignation, so we have no right, so another Village Employment Council was formed. Same thing was also stated by the private respondent in page number 63, my lord.
No, what happened to your FIR complaint case?
No, after that, my lord, when they have filed it, then we have filed a miscellaneous case before the learned single judge, called for record, particularly the resignation letter, Alice resignation letter. But the learned single judge has not entertained it and passed the order that we are suppressing the fact. So our case was dismissed, my lord. When we went to the office of the BDO, my lord, we found that there is no original, only the photostat copy of my
you're for the state.
yes, photostat copy of the resignation.
So, madam, do you have only a photostat copy of that?
Your Lordship, all this judgment, Your Lordship, has been passed on the ground that they have
We have read it.
suppressed
Yes,
the
no,
material
just- we
facts.
just want to know
All
from you.
this, they have brought it only now before
No,
this
no.
appellate court, Your Lordship.
In your file, you have a photocopy or the original copy?
We have to find out that, Your Lordship, because
Sorry?
that has not been, because that was never raised by them in the before the single bench, Your Lordship. Their main contention was that
No, do you have a photocopy or an original?
I'm not aware of that, Your Lordship, because
Produce a file. We shall see to it. You cannot act on the basis of a photocopy.
that is correct, Your Lordship. But all
You
these
cannot
points
act on
were
the
never
basis of
raised.
the photocopy when the original is there.
Lordship.
These points were never raised before the
No,
single
that's a
bench.
different issue, madam.
Your Lordship, may
But
kindly
you're-
see
but-
the
but-
writ petition.
No, we have seen that. But you have to. You cannot act on the basis of a photocopy. The original copy, if the resignation letter is there, then the original
That
original
we'll
should
see,
be
Your
with the
Lordship.
office.
Yes.
You cannot act on the basis of a photocopy.
But had
Then
they
he's
brought
able
it
to
before the
No,
the
that's a
single
different
bench,
issue.
Your Lordship, this matter could have been resolved there.
Yes, exactly.
But
you
because they
produce
had suppressed so many
so-
things, Your Lordship,
No, so you no. See, the learned single proceed on the basis that
there was suppression.
the suppression because of the fact they have already resigned.
Yes.
So what your learned friend is saying is this: the original letter of resignation was returned to me. It was never acted upon. So if it was never acted upon, then you cannot act. At least what we can do is this: you give them a hearing, opportunity of hearing, and proceed. If the original is produced before you, then you have to take a view that what is accepted, and you decide the matter afresh.
Because that on their resignation, Your Lordship, the VEC stood dissolved automatically. So there was another election held, and a new VEC was constituted, Your Lordship. So the matter stands there, Your Lordship. So on the new VEC being elected, they have raised that objection and come before this court, but they never brought it before the Lordship, excuse me, Your Lordship, that they had resigned from that.
No, if their contention is that they have not resigned, you see, you proceed on the basis of a photocopy of a document.
That contention was not there before the single bench.
No,
Your Lordship.
but he's raising it.
Now he is raising that. What was not raised before
No, but
the single bench?
when you reconsider it, then you proceed on the basis of what document they have submitted to you. Correct?
Yes, Your Lordship.
Did you ask for a verification from them?
Your Lordship, I
You
don't
should have asked for a verification from them.
Yes,
You are not required to be hard at this stage, sir. See, you are an authority. Once you receive a photocopy. You never act on a photocopy.
Correct, Your
Then-
Lordship. Now,
then-
on what basis they have acted?
Then you should.
Even
yes,
I am not
then,
aware.
then
Your
you should have asked for them that we have received this. What you have to say on this? You have to act independently and impartially.
Yes, Your Lordship.
If you have not done so, you have to redo it.
So we'll have to find out that, Your Lordship, whether there is an original
And if it's not there, you have to constitute. You have to call for a fresh or whatever
fresh
is there.
election or whatever.
Yes, yes. So you just produce the file, madam, and assist us on this.
Yes,
Stay
Your
down.
Lordship.
Lordship, may I submit, Your Lordship, just 2-3 minutes, Your Lordship.
The file will speak for itself.
No, Lordship.
Whatever you may say, the file will speak for itself.
Yes,
The
Lordship,
original
I
is
will
not
clarify.
there.
I will answer all the query of the court, Lordship.
See, you are.
Prime responding.
Yes, you are. You
We
are.
are the
part-
existing VECs.
Yes,
now.
you are the existing. Yes. So we go by the record. He said that the authority acted on the basis of a photocopy.
No, that is not correct, my lord. I will clarify you. What happened is this, my lord. May I submit? I am trying to answer this very answer why my lord is asking. Now, what happened? Now, my learned senior friend is trying to divert the issue. Here, the actual fact of the cases, it's happened. There is a VAC, is a term for 3 years. 3 years. After the 3 years, the VAC is constituted of president, secretary, and a woman member. Now, what happened? On the previous occasion, the VAC term of that particular village has come to an end. However, this appellate hearing, they were continuing even after the term, when their term is still over, when term has been expired.
So
They
after
were-
the term expired,
yes.
the law is this.
Now
that
they are
may-
still,
let me-
Your Lordship.
The law is this, that they will continue till the fresh election is held.
Yes, they're supposed to.
Continue
Yes.
till the fresh election is held.
Yes,
3 years.
So it is not so it is only after expiry of 3 years. So
yes.
if they have completed 3 years period
Yes,
and thereafter they are holding the office beyond 3 years,
yes.
then that is the authority concerned may ask for election to be conducted and select a new president.
Yes, exactly. Exactly. Now, in this case, what happened? Their term has been expired. And we are the one of the complainant. I'm the present existing VSC, President, Secretary. I'm President. Now, what happened? We were the job card holders at the villages. They will not know what happened, how despite of their term has been expired, they have been continuing. Therefore, we as a citizen, the villages, one of the villages, job card holders.
What you are saying may be absolutely legitimately correct. We are on a different point altogether.
No, Lordship, let me just complete,
the
Lordship.
authority can only decide.
Yes, Lordship.
If the authority can decide beyond this letter of resignation.
Lordship, I will come
let
to
them
that. I will
say
come
their
to
power.
that. Lordship, I will come to that point, Lordship. What happened is, we file an RTI. How the election is conducted, how the manner they are allowed to continue. When we filed the RTI, we found that this affiliate, he has forged all the signatures of the job card holders. They have forged all the signatures. They make a self document. It is there in the.
They have
I have-
forged
yes.
the signatures.
Yes, Lordship. Definitely, it is annexed. We have annexed also. This page 69.
Madam, you are representing whom, madam?
I'm representing the state officials.
States. So, I think we can dispose of this appeal
Yes.
by directing you to find out whether the signatures they have given in the particular paper was genuine or not. One, if they have already, term is expired, 3 years, then they have no right to continue till only they can say interim, just like an interim measure,
Yes.
till a fresh body is constituted, in which if they are eligible, they may participate. So you take a fresh decision on this.
May I please, Your Lordship?
Lordship,
Our Village Employment Council was approved on 6
Well,
May
they will take a
2024.
decision.
my
They will
lord.
take a decision.
Question
Take
of expiring does not
Lordship.
arise.
Lordship, after that, both a party filed the FIR. During the file FIR, party have come to compromise, and they have they have compromised. They have withdrawn.
and the state will take a decision on this. Take down.
May I please, Your Lordship?
Yes, yes,
Lordship,
yes.
I pray for accommodation, Your Lordship.
I can't hear you, madam. Please.
Lordship, I pray for accommodation in this matter, Your Lordship.
Accommodation, why?
Lordship, the conducting counsel is from Delhi and she's having some health issues. So if my lord...
You are no.
I'm Rahman.
Mr. S.K. Hassan appeared
Appeal last. I'm also
for the appellant.
For the appellant, Your Lordship.
You are junior to him
Your Lordship.
in this matter.
Lordship.
So he is going to address us.
Lordship. Lordship, my name is also there in the Wakalatnama.
Sorry?
My name is also there in the Wakalatnama, Your Lordship.
No, but your name is not recorded in the order, madam.
It's there in the...
Your good name is, madam?
M. Rahman, MS M. Rahman, Your Lordship.
Mrs. Rahman, not with me, even it's not there. Oh, yes. E.M. Rahman, correct?
M. Rahman, Your Lordship.
Hawk, no, sorry, M. Rahman.
Rahman.
M. Rahman, correct. This is matter, I think. Against the judge, a single judge. You are there in the bench. Yes. So you have further respondents.
Mr. Lordship, for respondent number 2 and 3, Lord.
Meghalaya, this
For
power corporation.
Power Department.
So you have not yet awarded the contract to anyone else.
No, Lordship.
It's a contract for?
Lordship 4, this is...
Notice in writing.
It's a contract for?
For selecting the exclusive
Operating partner for the
optical
OPGW
ground
passive fiber infrastructure.
Lordship.
Lordship.
So you have not taken a decision in the meantime. This
Lordship, this has been cancelled, Lordship. This thing has been cancelled, Lordship.
it cancelled for what reason?
Lordship is not financially viable, Lordship.
Not viable.
Lordship.
Lordship, they haven't provided any valid reason for the cancellation of letter of
See,
award.
if it is not viable for them, they can always, unless the withdrawal is mala fide, if they say that we are, because it was only an LOA was issued, correct?
Lordship.
So ultimately they decided that, well, it is not viable.
Lordship.
It is always open for the government to decide that it's not even at the stage of awarding a contract. So this is not, so you cannot ask for enforcement of a contract which the government feels that is not viable. So if they feel that in future they want to do it, you can always participate. As on date, please talk to your senior counsel.
Lordship.
You cannot ask for a specific performance in the writ petition. Normally, specific performance is not allowed, excepting in exceptional circumstances. So, even if you are seeking for a specific performance in a writ petition, you have to show that they are acting arbitrarily or in a mala fide manner. Now, in this case, as the right counsel, we have not gone through the papers, of course. If he says that after floating the contract, they found it to be unviable, unworkable, It's not that in future when they float the contract, you will not be considered. It's not a blacklisting for you. So what relief? They terminated not for any other reasons. What is the letter of termination?
My lord.
What is the letter of termination? Yes, madam, what is the letter of termination?
Lordship is 3rd of April 2024. Your
Page?
Lordship. Page.
Is it page 214? No, not this one. Yes, so they decided not to proceed because of the unviability of financial consideration.
Lordship.
To carry out the project for your benefit, it's a public money. Unless a policy decision is suffering from arbitrariness, suppose they want to give the contract to someone else and they cancel this so that again they float, they try to, it's a tailor-made contract or whatever is there. But here this is unviable for us.
Lordship.
And this contract was cancelled in 23. So even when the appeal was admitted, till that date they have not come out with any fresh advertisement, which would have shown that what you are saying may be correct.
Lordship. Lordship, may kindly fix the date, Lordship. We'll try to assess the court.
Yes.
My Lordship, fix after 4 weeks, Your Lordship, because the conducted
After
counsel.
4 weeks,
Your
we'll
Lordship.
forget.
Lordship, the conducting counsel is going through medical treatment, Your Lordship.
Sorry?
The conducting counsel is going through some medical treatment,
Yes,
Your
yes,
Lordship.
yes. But we'll forget everything, madam.
Lordship.
Stay down. Your turn.